Here, the appeal of Skatteforvaltningen against MCML Ltd, previously known as TDA and Capital Markets Limited.
Mr. Mallet.
My Lord, my ladies, I turn now to the question of what Mr. Justice Andrew Baker actually decided. But before turning to the judgment, can we just briefly look at the authorities which make it clear that what we are looking at is what was fundamental to the earlier decision? We invite you to follow the same legal framework that the court will find for the judgment of Lord Justice Newey. And if I could just briefly take the court to the relevant extracts. It's at page 166 of the bundle. And to go through the judgment on this particular point, it starts at 126, where Lord Justice Newey refers to Lord Sumption in Virgin Atlantic for the description of issued estoppel as the principle that even where the cause of action is not the same in the later case as it was in the earlier one, some issue which is necessarily common to both was decided on the earlier occasion and is binding on the parties. And that was the fourth principle from Virgin Atlantic that we've already seen. And my lords and ladies, that's an important starting point. We had thought the proposition to be trite, but yesterday my learned friend said on a number of occasions that because Skat's earlier claim in negligence and its current claim in fraud are different claims, no issue of estoppel could arise, and it's as simple as that. And that's the transcript at page 15, line 2. With respect, that's wrong, because it confuses cause of action estoppel with issue estoppel. On the contrary, issue estoppel operates precisely where the claims are different, and the question is whether nonetheless the same issue arises. Then Lord Justice Newey at 127 explains for something decided in earlier proceedings to give rise to an issue of estoppel, it must have been fundamental to the outcome of those proceedings. And in support of that, he cites Hoysted, where Lord Shaw held that issue estoppel extended to any point which was, and this is the important passage, in substance the ratio and fundamental to the decision. We say that that is a correct statement of principle which cannot be faulted. I will come back to it later, but just to note 2 points at this stage. Lord Justice Newey, like judges in many English decisions, including our appellate courts, cite Hoysted as an orthodox case of issue estoppel. Lord Panik's suggestion that Hoysted is somehow a case of dubious authority, we submit flies in the face of how this decision has been received in the modern law. The second point is that Lord Justice Newey cites Hoysted for the comparison of identifying what is necessary for issue estoppel by reference to the ratio of the decision. And we submit here that what Lord Justice Newey and Lord Shaw were saying is not that issue estoppel and judicial precedent are the same doctrine. Of course they are not, and we've never suggested that they are the same. But a common feature of the doctrine, and this is the point, is having to distinguish between necessary and collateral determinations. And in this regard, the interpretive exercise is the same. And we will revisit that particular point. But Housted is not the only...
So you accept he's not using ratio in the sense that we use it when we're talking about precedent in that sense?
Yes, it's the same exercise. And we've cited a number of cases which are footnote 17 of our written case, and I'm going to come back to some other material. But we say that is that the approach stated there is the correct approach.
What the approach stated in Hoysted as quoted by?
Yes.
Yeah.
That's my submission, my lady. Then we turn to paragraph 127 and 128, where Lord Justice Newey develops the proposition that issue estoppels arise from determinations that are necessary and fundamental and not merely collateral. And then at paragraph 129 on the next page, Lord Justice Newey cites Justice Dixon in Blair and Curran. Here he sets out what we say a litmus test is, whether the same issue as necessarily decided arises in a later case. He says matters cardinal to the later claim or contention cannot be raised if to raise them is necessarily to assert that the former decision was erroneous. In other words, if the later claim can concede only by asserting that the earlier decision was wrong, and there is no legally coherent way to distinguish the two, then the same issue necessarily arises again. And Lord Justice Newey continues the quotation from Justice Dixon and Blair and Curran, where he goes on to say, and I'm quoting, decisions upon matters of law which amount to no more than steps in a process of reasoning tending to establish or support the proposition upon which the rights depend do not stop the parties if the same matters of law arise in subsequent litigation.
And you agree with that, do you?
We do, and we adopt it. But Skat relies on this passage for the proposition that steps in the reasoning cannot give rise to an estoppel. But with respect, that's not what this passage says. What the passage says is that decisions on law, matters of law, which are no more than steps in the process of reasoning tending to establish a proposition cannot give rise to an issue estoppel.
But if you've got a decision that isn't a preliminary issue based on pure law, you could have a preliminary issue that just deals with a question of law. That would be the issue. But if you've got a decision about whether claims are admissible or inadmissible, and as a step in the reasoning to get to the conclusion about admissibility, there is a decision about the law, would you accept that was a step in the reasoning?
No, it's more than that, because unless you take that step away, the decision does not make sense. I mean, we can come back to this point, my lady, when we look at Curran, as we will do, and see how it was actually applied on the facts of that case. But in my submission, to say that the reasoning can't give rise to an estoppel, you can only analyse whether there is an estoppel where you find out what was decided and work out what was the reasoning that led to that decision. There's necessarily going to be an analysis of the reasoning. To say that estoppel doesn't arise because you have to, that's only looking at reasoning. But if it's a fundamental step that necessarily has to take place, we submit that the reasoning can give rise to an estoppel. And therefore we adopt.
I don't quite understand why you then agree with the last sentence of Justice Dixon's quote in Lord Justice Newey's paragraph 129.
Well, if it's no more than steps in a process of reasoning tend to establish or support the proposition upon which the rights depend, do not stop the parties if the same matters of law arise in subsequent litigation. I accept that. I mean, I do accept that. Okay. Now, we do say that that's the correct approach. I'm sorry if I misled my leadership.
No, you didn't.
But what this passage says is that decisions on matters of law which are no more than steps in the process of reasoning tending to establish a proposition cannot give rise to estoppel. But the key point is that but fundamental or necessary determinations of law can give rise to an issue estoppel even if they are found in the earlier court's reasoning, and that's my submission. And we can see that as a practical example from paragraph 130 from the judgment of Lord Justice Newey, which looks at how Blair was decided on the facts. And I could just invite you, the court just to read paragraph 130 to itself. I think you've seen it before. And I'll return to this case, but the short point is that the interpretation of the clause of the will was a step in the reasoning to the early decision on the passing of the widow's wife interest. Nevertheless, it gave rise to an issue estoppel because it was a necessary step in the reasoning. And that's the point that comes out of that passage. And again, we adopt what's said in paragraph 130. And the last sentence on paragraph 130, we also agree. that if there is no legal hypothesis which can account for the widow's wife interest passing under it, consistent with any narrow interpretation or effect being given to the clause, then that's stated. And so we make 2 points there. First, we say that this is recognisably the logic of identifying the ratio. What Justice Dixon was asking was whether the later case could be distinguished based on the necessary reasoning of the early decision. And the second point is that we say that this provides another litmus test for whether the same issue arises. To say that there is no legal hypothesis that could narrow the breadth of the determination is to say that the issue cannot be distinguished on the facts of the later case, and so the same issue arises.
But wouldn't that be the case if the issue had arisen between two completely different parties? They would have had to try and distinguish the earlier case from their case because it's a precedent that says that that clause in a contract or in a will has that effect. So what is it that he's saying that's different from what he would have said if the same point had arisen in a will between a different testator and a different legatee?
It's the same.
But it's not an issue estoppel between the different parties. It's just a binding precedent.
Yes, but it can't be an issue estoppel because the issue estoppel only arises between the two parties. I mean, that's the whole point about. So
you're saying that that an issue estoppel is really just saying that as between these parties, there's a binding precedent the same as would bind other parties.
Well,
I don't see why it has to be an issue estoppel between these parties when it has the same effect as a matter of law in relation to the same clause in a different will between different parties.
I mean, the point I think has already been made, how precedent operates in a different way.
Yes.
It operates effectively in a vertical way, whereas issue estoppel is horizontal, it's between the two parties. The point that I'm making is that the exercise, the way that one interprets the decision is the same or very similar to the way that one would go about determining the ratio of the decision. That's the point that comes out of Hoysted in the passage that which we cite, which is in substance the ratio and fundamental to the decision.
But I mean, doesn't a lot then turn on how narrowly you define
the issue?
The issue, because I mean, in Curran, and I think it's being said against you, what could be said is that what is determinative is application of a particular principle of law to very particular facts. You want the facts to read the facts element of that equation more broadly. Lord Pennock wants to read the facts element of that equation very narrowly.
Right.
At the moment, I'm not sure that Curran specifically answers that. I mean, I know you're going to take us there, and it may be that we'll get more help from it. But I'm not sure that there's a huge difference between you, because I think Lord Pennock accepts that at some point a decision in law, as applied to facts, is foundational for an issue estoppel. It's just that he says that the facts have to be taken very narrowly, and you're saying that the facts have to be taken as more broadly defined, so as to enlarge the scope of the issue estoppel. That seems to be the area of dispute.
And that is correct. And it may be that what we should do is park this until we've actually looked at the judgment.
Fine. I don't want to stop you, but
I see that.
I mean, I don't think anyone's saying law can never a proposition of law can never feature in the definition of an issue estoppel. I mean, and there's authorities that say yes, it can, but it's a question of at what point does a proposition of law narrow down onto a factual basis so that one can say of that issue, i.e. law plus fact, that an issue estoppel has been created.
Right. And as I say, I'm just sort of laying out the legal type framework.
All right.
I've got to then deal with the judgment, and then we're going to have to come
Certainly.
back.
I didn't want to stop you, but...
No, but I'm grateful.
Carry on with the framework, I think that would be...
Yeah, and so then we've had paragraph 131, which has been read a number of times, and I won't read it aloud. But the key point on which we submit is correct, is that far from being subsidiary or collateral, that was essentially the basis on which he determined what was before him. And we say that that is the correct analysis, but I need to now take the court to the judgment to show that. But before I do so, can I just deal briefly with the context or the background to the revenue rule trial, which my learned friend did very helpfully yesterday. But just to go through the chronology, we start off with the July 2020 CMC decision in the 2018 proceedings. And if I could turn to page 586. And paragraph 2 refers to the background, to the reference to the Mammoth litigation. He was a designated commercial court judge, actively case managing a vast and complicated set of proceedings involving numerous parties and causes of action. And that context matters. It explains why the revenue rule was identified early and treated as a distinct preliminary issue capable of disposing the claims across the litigation. And if we could look at the CMC order itself, at page 533, you can see the operative order or the provision at paragraph 5, where it says that the outcome of the revenue trial shall be binding on all parties, irrespective of whether or not a party filed revenue rule submissions or a skeleton argument or participated in the revenue rule trial. And the purpose was to resolve the revenue rule matter once and for all across the claims as a whole.
Well, so are you saying that the issue estoppel, the scope of the issue estoppel, as between Skat and EDFM on the case as pleaded against EDFM, can be wider because it was bound up in proceedings by Skat against other defendants raising other causes of action?
Well, no, I'm not making that submission. All I'm saying at this stage is setting the context. That effectively, what the judge was looking at was a trial. It was a preliminary issue, and it was going to bind all the parties, whether or not they participated. We, in fact, didn't participate. I don't know whether that's been clear. We did not make any written submissions. We did not appear at the trial because we had nothing further to say. No one was ever suggesting that the case could succeed, EDF man could succeed and the others would fail. We were all in it together. We had no separate submissions to make. And so we didn't participate, which is one of the ironies of this case, which is that we didn't participate and they didn't appeal against us. I mean, that's one of the bizarre features of this case, which I'm going to come to. But the point I want to do is just to stand back and look at this in terms of what was actually decided, which is that effectively, to take up a point I think that my Lady Rose concerned yesterday, suppose the revenue rule judgment had been handed down and for whatever reason Skat decided not to appeal, but then later Skat discovers 5 new vouchers. Can Skat circumvent the revenue rule by bringing a new claim in negligence on the 5 new tax vouchers? As we understand Skat's logic, they would say there would be no issue of estoppel because the 5 new vouchers weren't before Mr. Justice Andrew Baker. And neither would there have been precedent since first instance decisions are not binding. So Skat must say it can bring this claim subject to the discretionary bar on abuse of process. Yes. And we say that that's wrong. Why? We say because it's the new claim is effectively the same claim subject to the extra 9. It's actually in negligence on my example. But
it's effectively the same claim that includes quite a lot actually in what you're saying, because that goes or seeks to move away from what seems to be what is absolutely at the centre of this appeal, is how widely one defines the factual elements in what, going with what I was putting to you before. Is it just the claims that have been made, or is it claims that look like those claims?
But there's no material difference between the 5 vouchers and the...
Well, I think it's being said on the other side. There is.
Not on an admissibility issue. I mean, the cause of
action...
No,
but on an estoppel issue, it's being said the material difference is all the other vouchers were part of the pleaded case and therefore were necessarily decided by the resolution of the Dicey Rule 3 point because it killed those claims. But in your example, the 5 new vouchers were not part of those claims, and so they have not been killed in that way.
But that assumes that there's a material difference between the 5 vouchers and the
I agree, it does. But you're trying to say that there is no material difference because the claims look the same, even though they hadn't been pleaded out. They're saying there is a material difference precisely because the first lot of claims have been pleaded out and were, to use my word, killed by this resolution of the preliminary issue. But other claims which had not been pleaded out were not touched by the resolution of that preliminary issue. That seems to be if you like, defining the battleground between the two sides.
Yes, I mean, we can look at how that is consistent with cases like Watt and Arson, and I'll do that in due course. But it comes back to a point that I made last night, at the end of the hearing, which is, well, what are we actually dealing here? We're dealing with a rule about admissibility. In other words, what claims can come before the English court? And on the judge's analysis, accepted, because there was no appeal, there is no relevance of the different causes of action. The claim is inadmissible, whether it's in negligence, fraud, whatever it is, because the characterization of the individual causes of action do not go to the question of admissibility.
That's because of how he defined the Foreign Revenue Rule as a matter of law. And he may have been right, he may have been wrong. We know that, in fact, actually he was wrong, but for these purposes, we have to assume he was right.
Wrong. Yes, that's it.
So, but the question is, did the parties, Skat and EDFM, in their bit of the claim, did they ask him to decide that? No, all they were asking him to decide is, are the negligent misrepresentation claims in relation to these 420 vouchers, are they inadmissible because of the Foreign Revenue Rule? And that's what he decided. And
in doing so, they decided the issue estoppel, which is, as we say, which is whether or not private law claims seeking to...
They didn't ask him to decide that. In fact, his judgment, for various reasons, decided a lot more than they were asking him to decide. All they were asking him to decide is, are these claims in negligent misrepresentation in relation to these vouchers inadmissible?
And in deciding that, he came up with...
yeah, and that's the point of law that he decided, and that's a binding precedent unless it can be distinguished or overturned.
Well, I mean, binding, I'm avoiding the language of precedent because I'm focusing on
it's kind of confusing.
As between the parties, yes.
Yeah.
It may be...
But Skat couldn't have appealed that broader point as to all private law claims. They could only have appealed the point so far as it related to the 2018 pleaded case against EDFM. And likewise, had the point gone against you, you couldn't have pleaded, you couldn't have appealed the wider legal reasoning. You could only appeal the order made by the judge.
Yeah, I'm jumping ahead. I will come back to that when I go through the categories, and it may be that we should look at the judgment first.
But that's a good way of testing what was necessary to the judge's decision.
We need to go through that exercise. But all I'm saying is at this stage is that the 5 vouchers, perhaps I've come in at the wrong time to say that, but in my submission, the 5 vouchers, it depends on, in fact, I'll come back to the 5 vouchers because I think it's probably better to look at the judgment now just to see what was actually decided, and then come back to these important points that have been raised with me. I mean, as far as the judgment itself is concerned...
Can I just ask you before you do you agree that the judge wasn't deciding a pure question of law in the preliminary issue?
He was deciding an issue of law applied to the facts.
Yes.
Correct, yes.
Yes, so it wasn't a pure question of law.
Exactly,
okay.
Yes. We agree on that. Yeah, we in fact, it's dealt with by Lord Justice Newey at paragraph 135 at page 169. It relates to the foreign revenue law to a factual situation, one where Skat is seeking to recover refunds paid out on the basis of applications conveying misinformation. That's the last sentence.
Well, can I ask you this? I mean, isn't it inherent in the very fact that what was being determined was a preliminary issue where the judge was not going to go into the facts, as might happen at a full trial, that the only way we know what facts were to be treated as an issue is by looking at the pleaded claims? No other facts were in issue.
That's correct.
But isn't that damaging for your submission?
No. I mean, it actually reinforces the estoppel, because what it's showing is that the case is being decided on the basis of the facts as alleged. In other words, assuming the facts as alleged are true, as I think my Lord, or Justice Lord Jones said in the Supreme Court. It's taking the facts as alleged, that they are all going to be established. So it's taking its case at its highest.
But it's the pleaded case.
Yes,
it doesn't go beyond the pleaded case.
It's not going beyond the pleaded case.
So the 5 vouchers that weren't pleaded were not comprised within that pleaded case.
No, but it comes back to the point as to what was actually the issue, which is my point that I made yesterday,
yes,
which I'll come back to admissibility.
Applied to the pleaded fact.
To the admissibility issue, and I don't want. I'll come back to that point if I may. But just going through the judgment, if we can look at, there's really a number of points to make. The first is the structure.
Oh, I'm so sorry. Which judgment are we now?
Mr. Justice Andrew Baker. If we can page 219.
Yes, thank you. Yes.
Sorry. 196. Sorry, I'm just looking for the reference.
Yes.
You're starting at 219.
Yeah, and then if I can just in terms of the structure, there's a long
just on the point you made about representation, I note from the first page that it says that your clients were represented by their solicitors.
I think they were observing. I don't think they made any submissions.
Right. I mean, whilst that's an interesting fact, I mean, it doesn't matter that
it doesn't,
in terms of legal analysis, you had your chance to appear.
It doesn't matter, no. So if we can turn to the judgment at 219, having set out the law, he then applies it to the facts. And the passages that matter for our issue. And the point here is that we're not dealing with abstract law. We're defining it to a defined factual situation. And the conclusion on the revenue law rule is then given a short compass, leading, as you know, to the overall result that all claims fall to be dismissed. And the important feature is that the judge's answer is unitary. It applies across defendants and causes of action. And that structure is consistent with what Lord Justice Newey later described as a single determinative issue, not a series of voucher by voucher or cause of action specific determinations.
So you are saying, are you, that that the scope of the issue estoppel as between these parties is broader because the judgment addressed the revenue rule across a wider range of parties and claims, whether they were defendants in the same proceedings or consolidated proceedings?
Well, you could put that question another way. Had this only been a preliminary issue decided as between Skat and EDFM on the pleaded case based on negligent misstatement, would you now be saying that the fraud claim was caught by issue estoppel?
Yes, absolutely, and it is caught by issue estoppel because the judge has formulated and looked at the way that the claim is being brought by the Danish revenue in a way that the individual causes of action, and that includes the individual causes of action in negligence, are irrelevant. The individual causes of action are irrelevant for the purpose of the revenue law analysis. It doesn't make any difference what the cause of action. It does the same.
But then why didn't he just stop at paragraph 75? He dealt with the general legal proposition. Why did he even apply it to the facts?
Well, because he had to then look to see what the interest was that was being brought by the Danish revenue. What was the nature of the...
In relation to the facts pleaded, he had to look at whether the negligent misstatements whether the claims based on the vouchers, the reclaim claims, were direct or indirect enforcement of a foreign revenue rule.
Correct.
And he did that in relation to the pleaded claims.
Correct.
That's the issue estoppel, isn't it?
No, it's obviously the issue estoppel is the principle that these claims are barred by Rule 30. And that's a bar which does not involve any assessment of the individual causes of action. They are irrelevant. Whether it's fraud or negligence is irrelevant to the application of the admissibility decision under Rule 3.
I understand that they may be irrelevant to the application of the revenue rule, but they're not irrelevant, are they, to whether it creates an issue estoppel as between these parties?
The issue... Sorry, Madam.
Because the issue estoppel can only arise in relation to the application to the facts as pleaded, can't it?
Yes, of course, but it's the facts as pleaded in terms of to look at the function of what the Danish tax authority was doing. That may or may not have been pleaded. The issue is what is it that engages the revenue rule in this case?
Are you enforcing a revenue
exactly
rule?
And that's exactly what the judge looked at.
But only on these pleaded facts. He couldn't go wide.
Well, he looked at what was not in dispute in terms of what was being what was the interest of there was probably nothing actually in terms of an allegation about what the interest was that was being asserted and why the revenue was their powers, and I mean the rules are all there, but in my respectful submission it's a point that's not working at the level of pleaded and private causes of action. It's looking at the question of what is the interest that's being asserted here. Is it an interest and a process that gives rise to a claim that this is caught by Rule 3 of Dicey? And that's the way that no one, I don't think anyone is suggesting that the exercise that the judge did when he applied the facts was, he didn't say, well, this is pleaded at paragraph blank and this is pleaded at paragraph blank. No one is suggesting that the judge did anything wrong in the way that he approached the analysis. His conclusion was wrong because he misapplied the revenue rule, as we know. But in my respectful submission, it's not just simply a question of looking at the pleadings, it's looking at the relevant facts, and it's assuming that there is nothing in dispute on those facts, which gives rise to the principle that Rule 3 is applied. That's my submission. It's really, as I say, it focuses on admissibility and the irrelevance of the causes of action. So that's the first point in terms of it was involved an application to the facts, and those are the facts that are all set out in 76. No one has criticised the facts which are said to give rise to the revenue rule. He may have gone wrong in terms of the revenue rule, as we know he did, and the reason he went wrong is because the revenue rule only applies, as was held by the Supreme Court, where one is seeking to make a claim for unpaid tax, even if fraudulent. That's not what's happening here, and that's where the judge went wrong, and why the appeal was successful. But that's not against my client. I'm entitled to say that this judgment, and the question of issue estoppel in relation to the new claim, has to be assessed as against this judgment. And we can see how he came to that conclusion by looking at paragraph 86 of the judgment at page 221, where he identifies what he calls the foundational allegation. Every cause of action begins with the Danish tax form, and the core allegation is that the Skat paid refunds because it was induced by misinformation to conclude the refund was due. So he does refer to what is relevant to the cause of action.
Sorry, which paragraph was that?
86, my lord.
So is that the voucher? It starts with the voucher.
Yes.
So every case starts with a voucher.
Right.
Sorry, I'm just not picking up the word misinformation.
Well, the voucher accompanied the form.
Yeah, sorry, when you said
Yeah,
the voucher, you weren't quoting?
No.
No, okay, sorry.
So that's the common factual situation. Refund applications, conveying misinformation, payments made, and recovery sought by Skat. So that's paragraph 86. Paragraph 87, the next page, the defendant's essential point is not simply that the source of Skat's funds is taxation, it is that making dividend tax refund payments is an integral part of Skat's function as sovereign tax authority, and the return of a payment made by way of dividend tax refund is in substance a payment of tax. Skat's entitlement to which, of any, derives from its power to tax Danish company dividends in the first place. That characterization of substance, the defendants argue, should not be affected by the fact that if Skat is right on the facts, including as to Danish tax law, it was wrong to make the refund payment it now seeks to claw back. The WHT refund system is an aspect of the Danish system of dividend tax collection. A claim to recoup a WHT refund is a claim to reduce the amount of WHT given back, and a claim to reduce the amount of WHT given back is, in substance, a claim to increase the amount of dividend tax taken in. As it will become apparent, I agree. So he begins, and that's the characterization we submit, on which everything turns. That's the characterization that he found, and it obviously goes to the critical part of the decision, and as against my client, that stands. Maybe wrong, but that's what the judge found, and we can see the irrelevance of the causes of action, which is the point I made a moment ago. At 85, it says that if a claim seeking a recovery in tax refund made through an error induced by misrepresentation by the refund applicant is by nature a claim seeking indirectly or indirectly to enforce a foreign revenue rule. That is so much where the misrepresentation is dishonest, or where it is innocent or negligent, just as a claim for tax unpaid following an underreporting of or total failure to report taxable income, or an excessive or invalid claim of deductible expenses is a tax claim, whether the misdeclaration or failure to declare is honest, careless, or dishonest, depending on the rules of the system of law that would govern it and the nature of circumstances of the particular defendant, fault of some kind or matter may be required for liability on a private law cause of action if available, but that is a different point. So in other words, he makes explicit there the distinction that matters for this appeal, that whether a misrepresentation is dishonest or negligent may matter to evidence of the private law cause of action, but is a different point from the revenue law question he has decided. In other words, he's not decided the ingredients of each individual cause of action. He's not looking to see the elements of a cause of action in negligence compared to a negligence in fraud. He's deciding an admissibility defence by characterising what the claims are in substance seeking to achieve. And that analysis remains the right, whether it's negligence or fraud. And so even if this was just between us and Skat, this is the analysis that he's applying. It's not making any difference.
But he then ruled the claims inadmissible.
Correct.
The 2018 negligent misstatement claims.
Correct.
You're inferring that had there been a fraud claim as part of the 2018 proceedings, based on 89, he would have reached the same conclusion. And I agree with you.
It's not an inference. Sorry, my lady.
Well, why isn't it?
It's not an inference. He has to decide it that way because he's already said.
But he hasn't decided it.
It must be an inference. He didn't have it before.
Well, if it's...
It wasn't before him. It wasn't part of the pleaded case.
But the thinking behind the conclusion that the revenue law, the revenue rule applies to on the claim in negligence. The reason that he's deciding that is got nothing to do with the individual cause of action.
I understand that, but he can only decide the case that was before him, which is the contours of which are bound by the pleaded claim, aren't they? I mean, he can't decide the case on the 5 vouchers that weren't before him, can he?
It's the same as the Watt and Arson case, where there was one complaint. The court found that the Labour Party was basically the qualifying party. There were 2 later complaints, different facts. The Labour Party may be different as well, but still there was an issue of estoppel.
Well, so only as to whether the Labour Party was a qualifying body, not as to whether those complaints were made out.
But that was the complete answer. That was the admissibility issue, the jurisdiction issue that mattered in that case. So my point is that if one is characterising this as a principle of admissibility, where the question is, are these the types of cases that we are going to hear in this country, or are they barred by the revenue rule? If the question is then decided that as a question of characterisation, these claims are not going to be heard, and also that it doesn't make any difference. It doesn't make you don't change any legally relevant fact by saying I'm now suing in fraud rather than negligence, because the distinction, the change that you make by moving from negligence to fraud is legally irrelevant to the question of admissibility that is being decided by applying Rule 20, the individual causes of action. So the point that's being made to me, well, it's a different cause of action, therefore there must be something different. They can argue the point again. But where the point of admissibility is being made on the basis of this characterisation, these types of claim, and where the cause of action is irrelevant, no one can explain why a different.
Sorry, if you'd said to the judge, please decide as a preliminary issue what types of case will be heard in the UK that are barred by the Foreign Revenue Rule, the judge would have said, I'm not going to decide an academic point.
No, he wasn't.
Decided it.
No, but I mean, if anyone had gone to Mr. Justice Baker the day after his judgment and said, "Well, I now want to bring a claim in fraud against these individuals," the judge would say, well, "That's decided against you. It's been."
Well, he'd have said you're likely to lose, but it hasn't been decided.
He's bound to say that you've lost because he's defined the rule in
because he's set a precedent there as to what the scope is. It's not because it's an issue.
But take the example of someone coming before him the day after he's given this judgment. Suppose there was another claim in the wing, so different defendants, but Skat bringing the claim, and their trial comes or preliminary issue comes on the day after he's given his judgment here. I would have thought that logical consistency means that he would apply the proposition of law at paragraphs 87 to 89 in that new case. So he would equally dismiss their claim as well.
Well, that's precedent, and that's
right. Well, that's what I wanted to press you on. I mean, surely you couldn't say that there's an issue estoppel binding those parties.
I couldn't say there's an issue estoppel because the parties are different. This is only as between the issue estoppel only operates between the parties have to be the same. So issue estoppel only arises as between us and Skat.
So why isn't the right way of looking at paragraphs 87 to 89 in Mr. Justice Andrew Baker's judgment, that it's there that he's defining the general proposition of law that he will then seek to apply to the particular facts in the case, just as he would seek to apply it in the example that I was giving you of the case that comes on the next day.
And he does.
So you're agreeing that he's defining.
He applies it.
But then we know for issue estoppel, it's not enough just to define a proposition of law. It has to be brought into a relationship with particular facts. And what's being put to you is, aren't the facts that he brings this proposition of law into relation with those which are defined in the pleadings? Because those are the only facts he has. It goes back to what I was putting to you. This is a preliminary issue. There is no trial. Sometimes you have a trial and other facts emerge. But the only facts in the game, in the picture, so far as the hearing before Mr. Justice Andrew Baker was concerned, were those which were pleaded, aren't they? I don't remember whether there's anything that goes beyond. I'd be surprised if there was anything that was. I don't see how there could be if there's no trial.
Exactly. So there was no witness statements. But the point that we're looking at is, how does one describe the decision that was reached by Mr. Justice Andrew Baker based on what was before him?
Sure, but how one describes it for the purposes of the law of issue estoppel.
Yeah, and then as applied on the yes.
And the reason that I qualify it in that way, which seems to me potentially a significant way of qualifying it, is we've looked at authorities. Maybe you'll seek to dissuade us that this is the proper picture, but at the moment, the authorities seem to say that what creates the issue estoppel is bringing a proposition of law into relation with a particular fact. It's that relationship that generates the issue estoppel. Sometimes it's just a decision on fact, but we're looking at law in relation to fact. And here, yes, we've got a proposition of law that seems to be defined in quite general terms by Mr. Justice Andrew Baker. Hence, he would have to apply this to an equivalent case that cropped up tomorrow. But for the purposes of the law of issue estoppel, isn't this right? We need to identify that proposition of law being brought into relationship with a particular set of facts. It's only where you have those two things together, that relationship, that you generate an issue estoppel. And I think we're all putting to you, well, this is a general proposition of law. It would have, you can describe it as precedential value. It certainly would do for Mr. Justice Andrew Baker, because he's certainly going to apply that in future. And even a first instance judgment has some precedential value as persuasive authority. So yes, it has precedential value. But isn't it right that in order to generate an issue estoppel, you need to bring that broad proposition of law into a relationship with a set of facts? And then you ask, well, what set of facts is it being brought into relationship with?
Yes.
And the only, at the moment, the only candidates that I can see are those which were pleaded, because those are the only facts that he's looking at.
Yes, and the pleaded facts are all about Danish tax authority, their powers. It's about refunds. It's about seeking recoupment in relation to misinformation.
Right.
And that's the issue. And
but it's being put against you, so let me put it to you here. It's being said, so far as EDFM, the claims against EDFM were concerned, there was no pleading of fraud. It was all put in negligence. And moreover, by contrast with the 2022 claims, and moreover, there were particular features of the tax vouchers which are now said to be misleading in ways which were not said to be misleading before. So you've got these two additional elements, it's being said, of the facts which are being presented in the 2022 claim, which were not present in the 2018 claim. And so, I'm just playing back to you the case against you. And it's being said, given the nature of the doctrine of issue estoppel, which, as I say, on my current understanding, arises out of propositions of law being brought into a relationship with facts, the only facts in 2018 were those pleaded then, did not include these two additional elements in 2022. Therefore, the argument is being put against you. There cannot be an issue estoppel in relation to those additional facts which were not decided upon by the judge in his preliminary ruling.
But the judge was deciding an issue which had nothing to do with individual causes of action for the purpose of the rule of inadmissibility.
Yeah, but isn't that just to say that the proposition of law that he identified operated at a higher level of specificity and would comprehend more fact situations than those that were directly in issue before him? Isn't that all that is to say?
Well,
and then if that's right, isn't the riposte to that, I'm putting to you to get your response, but for an issue estoppel to arise, it's only when that broad proposition of law is brought into a relationship with particular facts that an issue estoppel, a very powerful thing, arises. And the only relevant facts for that proposition were those which were pleaded.
Yep, and the judge took the approach. I'm prepared to accept everything that's been alleged on the pleadings. I'm not going behind the pleadings.
No, of course.
But the point of the revenue rule is that it's a rule of law that applies irrespective of what the causes of action are. The causes of action are irrelevant when one comes to look at what the revenue law. The revenue law is concerned with matters that are not relating to any of the causes of action, applies across the board. And that,
if I may say so, I follow all of that. It seems to me that that's inherent in what I was putting to you, that Mr. Justice Andrew Baker has identified a rule of law, the revenue law, that is a very wide ambit. It catches all sorts of causes of action. Hence my example of, suppose he had, another case the next day, different parties, but a similar area, caught by this broad rule of law, the revenue rule, he'd say, well, it's caught by the revenue rule. But that, what I'm putting to you is, on my understanding, that's not enough to establish an issue estoppel. An issue estoppel only arises when you bring that broad proposition of law into a relationship with particular facts. And then the question is, well, what facts?
Yes.
And
which is the facts that the judge identified. We've got no problem with that analysis.
Right, okay.
And the facts that the judge identified are I'll come to this when we look at other parts of the judgment.
Yeah, sorry.
But I mean, it may be that there is not that much of a dispute between what we're saying. What we're doing is we're looking at this judgment to find out what is fundamental, what is necessary to come to a decision based in relation to the way that the case is being put by the state. And in my respectful submission, I'm repeating myself. It's looking at the nature of the interest that is being asserted that catches the revenue rule, and it's an analysis and finding, and it's fundamental to that determination that one is not looking at the elements of individual causes of action because it applies across the board to this type of claim, in other words, private claims involving misinformation, where there's an attempt to recoup assets. So those are the constant factors. It's a state, it's recruitment, it's misinformation, and that engages the Rule 3, Rule 20.
Just one last question from me, if I may, in the way that you're putting it. You say it's fundamental to his determination, and of course, in a sense, it is, because if you say that there's a rule of law, let's say, that covers and applies in cases X, Y, and Z, and I'm dealing with a case Y, well, in a certain sense, identifying that rule of law is fundamental to your reasoning, because you're going to say, and this is case Y, and therefore the result is given by my identification of the rule of law. But the very fact that you've identified such a broad rule of law that can apply to in cases X and Z as well as Y tends to indicate, doesn't it, that it's not enough just to say, well, it's fundamental in the sense that here's a rule of law that's being applied in this case, because I don't think you're saying that the identification of that rule of law would create an issue of estoppel in any other case, in my example, falling in situation X or Z, even though it would have precedential value in those situations. So you say it was fundamental that the Mr. Justice Andrew Baker identified the revenue rule in the way he did. And of course it was, because he needed to know what rule of law he was applying to the case. But it doesn't seem to be sufficient to identify it in that way to generate an issue of estoppel just because it was fundamental that he was applying a general rule.
Right. We say it's fundamental because what Mr. Justice Andrew Baker was doing was characterising the Skat's claims. And the question that arises is, well, what is the only determination which is capable of explaining the dismissal of the claims? And that's the dismissal of EDF, the claims against EDF. It's the claims against all the various parties. And if you remove that characterization, the dismissal has no legal foundation. There's no narrower hypothesis that accounts for the result. And the judgment itself rules out any suggested distinctions. And that's why we say Lord Justice Newey was right at 131 when he said the determination was fundamental. And Lord Justice Newey agreed, subject to his pure point of law concern, and he accepted that one can see the argument that it's determinative of the present proceedings. And in my respectful submission, Skat can't point to any alternative analysis of the judgment that descends into the factual detail of the individual claims.
But isn't that because the judge has identified a broad rule of law that, because of its breadth, it catches all these things? So it becomes, in terms of the application of that broad rule of law, it doesn't matter the fine detail of the different causes of action, because they're all caught. And that seems to be precisely the point that he's making.
Yeah, we agree.
In 87 to 89. Yeah. But that's just reflecting the nature of the breadth of the rule of law that he has identified and is now applying. And that, again, I don't want to take up more time on this because we've asked you lots of questions about this, but I'll just finish with this question. It doesn't seem to me at the moment that just because you've identified a broad rule of law that could apply in lots and lots of cases, and you happen to say, oh, and the case I'm dealing with happens to fall within that rule, that you have created an issue estoppel which goes the whole breadth of that broad rule of law.
Individual defendant.
Yeah, so that individual defendant, because, or for anyone, because that's just to say, well, there are lots of cases that fall within the ambit of this rule of law. That's the nature of that rule of law.
But I would still submit to the court that we're not applying an abstract rule of law. We're applying a rule of law, or rather a principle,
To what? To what?
To the facts before the court.
But the only facts before the court were those which were pleaded.
Correct.
So why, forgive me for putting it in this way, why is that not an extremely damaging way for your case to look at the matter? You have an abstract rule of law. I think you're accepting that for issue estoppel to arise, it has to be brought into relationship with a set of facts. And then what's being put to you is, and the only facts it can be brought into relation with, almost ex hypothesi because of the nature of resolving a preliminary issue, are the pleaded facts. Right. Not every fact that could have been pleaded, not every cause of action that might have been brought against EDFM, just the facts that were pleaded and giving rise to the causes of action that were pleaded, i.e. just negligence.
Yeah, but I think it's important to have regard to the fact that although there were a lot of pleaded allegations, they weren't relevant in terms of whether the rule applied or not. I mean, there are lots of different types of allegations.
Yes. I think we'd better let you develop your submissions. We've asked you quite a lot of questions, and it's important you be allowed to get on.
No. I mean, as I say, I'll come back to that.
Yeah, by all means, yeah, by all means.
But I mean, it's important we submit. We've only stopped at 2 paragraphs.
I know.
There's a lot of other paragraphs.
Yes.
Which, in my submission, assist what I'm saying.
All right.
In terms of how we understand what this decision is.
Yes.
So, for example, the judgment rejects in terms any attempt to avoid the revenue rule characterization by relying on alleged mechanics of the trading, including assertions of sham transactions, closed loops, or the absence of any real share ownership.
Which paragraph is that?
Paragraph 111. So all of these are pleaded allegations which are irrelevant as the judge sees the matter in terms of the question of characterization which he has to do. Because it's been constantly said to me, well, you've got to look at what's pleaded. And in fact, there's a lot of pleaded allegations that have got nothing to do with the revenue rule. And one's got to, in my submission, the question is not what is pleaded. The question is what is the characterization that's being concerned here? Is it a characterization that has anything to do with the individual causes of action? And if it's got nothing to do with the individual causes of action, a distinction between negligence and fraud is irrelevant. It's an investigation, and it's being said to me, well, this is negligence, but we're now fraud. But if on the characterization that distinction does not matter on the pleadings, as interpreted by the judge, in my respectful submission, it's not an answer to say, well, this is only dealing with negligence. This has got nothing to do with fraud. You're making a case by way of inference. No, I'm not. This is fundamental to the judgment below, that we're not concerned with looking at private cause of action. We're not looking at whether this is a fraud claim or negligence case, because it makes no difference. And in my submission, that comes out from this passage here at 111, where the plea is made. And then the judge says at 112, he said, this does not, in my view, alter the proper characterization of Skat's fundamental resulting claims. It says it remains the case that their fundamental premise is Skat's contention that...
Well, he says, for the purpose of Dicey Rule 3.
Correct.
And that's to identify the breadth of the proposition of law that he's going to be determining and then applying for the purposes of the preliminary issue.
Yeah, I mean, the first question is the point of law, is whether the point of law was necessary to decide the earlier case. At this stage, of course, it's necessary that the law is applied to the facts. And here we look at what the judge actually did. He did not say my decision covers X, Y, Z. He said there are no relevant differences between X, Y, Z. The law is applied to the facts as he saw relevant. And it's inherent in issue estoppel that that issue can then be lifted out of those facts and applied to different cases with different facts, and we see that from cases like in Blair. But the point I'm making is here is that we're dealing with the fundamental premise, which is recorded here, and the individual causes of action are not relevant to the proper characterization of the claim. And he put that submission and 113 as well. So that is my conclusion also as regards the one way in which the fictitious or sham transactions plea is put.
But then at 118, he goes on to say the result of all of that is Skat's claims are inadmissible because they enforce directly or indirectly this foreign revenue rule.
Correct.
And therefore those claims are inadmissible. That's the issue estoppel, isn't it?
That's the cause of action estoppel. I mean,
No,
that issue.
that's the issue estoppel.
The issue estoppel is what was necessary to decide that. That's the distinction. I mean, one's trying to work out how he came to that conclusion, and one can't just simply say, well, because I've decided that the negligence case or claim is caught. That doesn't tell you anything about other claims, because they obviously are separate. But that's in our respectful submission confusing cause of action estoppel with issue estoppel. But I mean, just to finish off this particular point here at 113, you can see that he deals with fictitious or sham claims, and how that doesn't affect the claim at all, because the character and quality of the payment made by Skat is the same. It is inherent in, and in essence, the central issue test of ascertaining the substance of a claim brought by or in the interest of a foreign sovereign, that the character or quality of the sovereign's relevant activity is the most relevant consideration. And then he goes on to say the strongest version of Skat's case, alleging that the transactions were not contracts at all, is ultimately just a particular way of accusing WH applicants of having not merely claimed incorrectly to be limited tax, Danish taxpayers eligible to tax, but pretended to be such. That does not change the character and quality of the Skat's relevant activity. So there the judge proceeds expressly on the assumption that the alleged transactions were entirely artificial, no shares existed at all, and nonetheless holds that that makes no difference to admissibility. Even on that hypothesis, the claim remains one to claw back tax refunds paid out by Skat in its capacity as tax authority. And so we say that that reasoning is critical because what it shows is that the existence of the shares, the reality of the trades, the mechanics of the transactions, the causes of action are legally irrelevant to the revenue rule analysis. And that's why the issue is framed as a level of substance. Once it's accepted that Skat is seeking in substance to recoup tax refunds it paid out as a tax authority, the presence or absence of real trades or real shares cannot affect inadmissibility in exactly the same way that the causes of action don't make any difference. And that's the point that I'm trying to get across to the court, which is I'm being asked to postulate different types of causes of action and why that makes a difference, or it might make a difference. Am I making just an allegation about inference? No, in my respectful submission, this judgment can only be understood on the basis that he is concluding that private causes of action, in other words, negligence versus fraud, are irrelevant. One is only concerned here with what the Danish tax authority is doing. It's about misinformation. It's about seeking to recoup tax. And that is what is caught by the revenue rule on the judge's determination. And they didn't appeal that against my client. And that's the reason why we say that it's fundamental. It's not collateral. There's an issue of about identity, but in my respectful submission, that doesn't arise because as Lord Justice Nugent said, the misrepresentations are statements on the tax vouchers. There's no identity point, and in our respectful submission, that's a complete answer. So if I can just sort of tie this together.
Oh, sorry, you tie it together.
As you wish, my lady.
Well, just my concern is that then it makes the scope of the issue estoppel dependent on how the judge drafts his judgment. That he could have drafted it like this, or he could have started it with saying, all I'm dealing here with is negligent misrepresentation claims. I'm not dealing with any other kinds of private law claims. And that would have disposed of EDFM claim if he'd decided in the same way. But in fact, he decides to go further and say it covers all private law claims because he's dealing with a mass of different claims. But that's not in their control, how he drafts his judgment and the scope of what he decides. That they only know when they get the draft. But does that then mean that they're at risk, depending on how he writes the judgment, of having a broader or a narrower issue estoppel?
Well, in my respectful submission, that had if we're doing a hypothetical on the basis that there's just two parties, Skat and EDF, with none of the other parties, in my respect, the judgment would have been the same. He would have considered the question about the causes of action being in negligence, and would have said that this is irrelevant. I mean, I'm deciding an issue of admissibility. My decision about inadmissibility has got nothing to do with whether this is a claim in negligence or not. This is a claim that applies in negligence. And I don't need to say so. It would have made no difference whether the claim was in contract, bailment, or whatever. This is a type of activity by a state which is called by the revenue rule. Of course, he was wrong, but that's what he decided, and they elected not to appeal it. So my submission is drawing these threads together. The first point we make, just by way of a wrap up, is that the judge addressed the revenue rule as a single dispositive issue. It wasn't voucher specific. It wasn't claim specific. It did not involve the consideration of the elements of any individual cause of action. It made no difference to the judge's analysis whether it was a contractual, tort claim, deceit claim. It made no difference at all. The second point that comes out of this is that he identified a common factual situation or factual core, which would be the same factual situation or factual core, whether it was one defendant or multiple defendants. In other words, refund applications conveying misinformation, payments made, recovery sought by Skat, and treated as that as sufficient for the admissibility analysis. The third point is that he rejected attempts to avoid that analysis by reference to the detailed mechanics of the alleged trades, including allegations of sham transactions, closed loops, or the absence of any shares at all, holding that these matters were irrelevant to admissibility, even if assumed to be true. Fourth, the characterization he adopted that these claims were in substance enforcement of Danish revenue law was the only basis upon which the dismissal of the claims can be explained. And again, that's the case whether it's just one defendant or all of the defendants. It's clear, we submit, that this is the only basis that the claims can be, the dismissal can be explained. And that, we say, therefore, was that was a determination that was fundamental to the judgment. It's the issue identified by the Court of Appeal, and it is that identical issue and factual core to which it relates that arises in the present proceedings. And further, we saw from Lord Justice Newey's summary of the legal framework, there are two ways of determining whether the same issue arises between different claims. First, one can ask whether any newly pleaded facts are capable of changing the revenue law characterization adopted by Mr. Justice Andrew Baker. In other words, are there any new pleaded facts that are capable of changing the revenue law characterisation adopted by the judge. There are none in my submission. Nothing that is being said in the new case changes the characterisation which forms the fundamental basis of Mr. Justice Andrew Baker's decision. The second way to test it is one can ask whether Skat could succeed in the 2022 claim without denying that that characterisation was correct. In our submission, it cannot. That is because success in the present proceedings would require the court to accept that claims of this nature to recover WHT refunds paid out by Skat on the basis of misinformation are not, after all, barred by the revenue law. That is precisely the proposition rejected in the revenue law judgment. The factual differences on which Skat relies are therefore beside the point. They do not engage with the reasoning of Mr. Justice Andrew Baker, and they cannot avoid the conclusion that the same issue arises again in identical form. And we say, in relation to the 5 new vouchers, that where an earlier determination consists of a legal characterisation applied to a defined factual situation, the later introduction of further instances does not give rise to a different issue, unless those instances introduce some fact material to that characterisation. So one is looking there for saying...
Sorry, could you just say that again? The later introduction of further instances doesn't give rise to
a different issue, unless those instances introduce some fact material to that characterisation. I'm sorry if I went too fast.
Yeah, that's great, thank you.
And as I say, we can test this by asking what would happen if, following the judgment, Skat had issued a fresh claim in negligent misrepresentation listed to the 5 vouchers, which was raised with me earlier. We say that it could not sensibly be suggested that that claim could escape issue estoppel. No fact material to admissibility would have changed in that example. The same issue would arise and the claim would be barred.
By issue estoppel, not by abuse.
Correct. And pleading those same vouchers now in fraud and alongside other vouchers cannot put them in a better position. Neither the addition of further instances nor a change in the pleaded cause of action alters the inadmissibility characterisation already determined. So putting that again, so that if the claim is brought in fraud, the question is, has any new fact been raised or alleged which changes the characterisation that led to the dismissal of the negligence claims? And in my submission, it doesn't, because of the way that the admissibility rule has been applied by Mr. Justice Andrew Baker, and of which there was no appeal. Now, if I may, can I just deal with Skat's case? And this, to some extent, is going into what might be regarded as issue 3 or ground 3, because and this is a question of why was there no appeal from Mr. Justice Andrew Baker in relation to EDFM. And this is obviously relevant into the ground 3 special circumstances. But in my submission, it's also has, well, let me just explain how the point arises. I learned a friend yesterday sought to explain why Skat did not appeal against us on the revenue rule. And with respect, his explanation does not solve what might be called the puzzle, which we say is highly relevant to whether or not Skat should be permitted to argue special circumstances and whether they are made out. We say that my learned friend's explanation yesterday is not Skat's first attempt to explain its decision not to appeal against us on the revenue rule. However, previous attempts have simply led to much judicial head-scratching, and we submit the latest attempt falls within the same category. What my learned friend said yesterday, and I'm quoting from the transcript, I haven't got the page number, but what he said, the revenue rule was not pursued against EDF, and the reason why it was not pursued against EDFM are set out in Lord Justice Nugie's judgment at paragraphs 30 to 31. Skat took, as it was described, a pragmatic approach. It focused on what it saw as the main defendants against whom it took the view it had evidence to sustain an allegation of fraud, but it didn't then have the evidence as against EDF, and EDFM's man's case was more complicated in that Skat could not plead that there were no shares involved in EDFM's case. If I can just make 4 quick points, short points about that explanation. First of all, my learned friend suggests that the reason for Skat deciding not to appear was resolved effectively by Lord Justice Nugie. But with respect, that is correct. If I can take the court to paragraph 4 of the judgment at page 134. Your lordships can see it at paragraph 4, line 2, that the judge said there that Skat chose not to appeal as against, and the reasons remain somewhat obscure. So he wasn't satisfied that he had at least a clear account of why that was the case. And if we turn to paragraph 31 of the judgment, which my learned friend cited, you will see from that at page 141, at paragraph 31, 6 lines down, that was not a finding by Lord Justice Nugie about the reasons for Skat not appealing. This simply restated what had been previously said by Skat's counsel in the Court of Appeal. Further, even in relation to that explanation, Lord Justice Nugie notes that the transcript shows that it caused some puzzlement. That's at paragraph 31, about 10 lines down. That brings me to the second point.
But sorry, just so that it's clear in my mind, are you referring us to these passages on the de bene esse part of the ground 3, saying that they shouldn't be allowed to run it in this court, or to show that special circumstances do not exist?
For both.
For both.
Both reasons.
Okay.
I mean, your lordship has the point, but it's to do with the question, well, why didn't you appeal? There is actually no material before the court as to why there was no evidence about why there was no appeal. I mean, it's simply obscure, as I will show. And so my second point is which is why we took the
But just on that, I mean, as I understand it, a lot of these matters were gone into on the Henderson and Henderson abuse part of the case before Miss Justice Bright and the Court of Appeal. I mean, similar questions would arise. Well, why didn't you appeal? Is a sufficient explanation put forward to show that it's not a Henderson and Henderson abuse? And both Miss Justice Bright and the Court of Appeal say, well, we don't have a full picture. It may be that that's to do with legal professional privilege or whatever. We've got what we've got. Nonetheless, we're satisfied that there isn't an abuse in those terms, in the point being taken now. My question is, why should we adopt a different position, admittedly on the different questions of whether we allow the point to be argued before us, and also on whether special considerations arise? If it wasn't an abuse for them, Skat, not to have appealed, why should they should be precluded from raising the special consideration?
And the answer is that we're conflating different doctrines. One is abuse of process, which is, can a fraud claim be brought under Henderson and Henderson abuses. The second question, the question we're concerned with and why we're looking at this now, is issue estoppel. Are there special circumstances? Is this a case like Arnold, where they were unable to appeal? In Arnold, they were unable to appeal because Mr. Justice Walton refused to issue a certificate that was required under the Arbitration Act. Therefore, it could not go any further. In our case, there's nothing to indicate why they couldn't appeal, other than the fact they took a pragmatic, forensic decision. And in my respectful submission, that is not enough to amount for special circumstances. But I also say is that when one looks at the material, one has simply not got an answer as to why there was no appeal. And if the true analysis is that there's no material, special circumstances don't come into play because the court hasn't got the material to answer the question, well, the obvious thing you should have done was to appeal, and you didn't. So in my respectful submission, there's a difference between abuse of process in investigating what happened and why something wasn't pleaded, to the question of can you invoke special circumstances on the basis that you were unable to appeal, or that the decision not to appeal was understood. In my respectful submission, there is no coherent explanation as to why there's no appeal. It's simply, as I say, incoherent. I mean, it's said to be pragmatic. If that just simply means forensic, tactical considerations, well, in my submission, that is not a special circumstance. The party can make whatever tactical decisions they want, but they can't then, if they turn out to be wrong, reverse them and say, well, now we want to raise special circumstances. So that's why we're looking at this. In other words, there is no coherent explanation before the court as to why the appeal did not take place. That's the only point I'm looking at this stage.
Yes, thank you.
And so if the second point is that if we look at the transcript briefly, which is at page, the document, tab 27, page 752,
This is the transcript.
before in the Court of Appeal, on the first time round.
Yeah.
Oh, right, yes. Just help me. So this is a hearing before the Court of Appeal, a different Court of Appeal, on what exactly?
On the revenue rule.
Oh, right. Yes, I see.
This is the appeal from the revenue rule
That's
judgment.
correct, my lady. And just to... Mr. Feely came in after my learned friend will panic to deal with this. And Lord Justice Flo says at page 9, take your course, but there is one of the questions that we're concerned about, or in fact at line 14, it would be of great assistance to the court to have some clarity on why ground 1 is not pursued against EDF. And that's where Mr. Feely then comes in. And you can see his response at paragraph 22, that he says it was a pragmatic approach of focusing the appeal on the fraud claim. But just to put that into context, Skat was pursuing ground 1 of the appeal against non-fraud defendants. There were other defendants when non-fraud was being a party. So it's not as if they decided to drop all non-fraud defendants.
But there were no other parties against whom only negligent misstatement had been alleged.
Well, I'm not sure that's right. I think
they're
non-fraud.
That's what we were told, I thought, but I might have misremembered that.
I certainly thought that was what we were being told yesterday.
No, I think there were...
We were told that negligent misrep was alleged against EDFM, but the other claims were all included fraud.
No, if you can turn to document 318. This is their particulars of claim.
Page?
318, my lord.
So, Mr. Mellett, you'll have to help us with this document, which we haven't looked at before. What is it?
This is the pleading of Skat, and this is the version as at 31st of January 2020.
Against
and
who?
You can see that at 317 at the top there. And it's a re-amended particulars of a claim.
Against whom? Global partners.
Yes, and against everybody.
And others.
Yeah, this was the particulars of claim. And if you can then turn over the page, we see at 318 a reference to who the non-fraud defendants are. And that's at C. And so there's a whole series of defendants against whom no allegations of dishonesty are being made. So we understood that we're the only ones that were dropped out, but non-fraud defendants were still being pursued.
Can I speak to...
Of course, yeah, of course.
My friend's permission. What I said yesterday is that Skat was the only defendant in respect of whom there was no allegation of fraud and the underlying transactions were not alleged to be fraudulent. There were other defendants who were not themselves accused of fraud, because we had no evidence to that effect against them, but we did allege that the transactions which had led to payments to them were fraudulent. It's slightly complicated, but those are my instructions, my understanding.
Of course, I accept that. I can't verify it myself, but I'm obviously coming from Lord Panic. That's good enough for me. But I mean, the other point is that Skat was still pursuing ground 2 against us. It wasn't as if we were being let out. They just didn't want to make these allegations ground 1 against us. So we remained a party to the appeal on ground 2, despite being a non-fraud defendant. And of course, although this is and then the next reason that was given by Mr. Feely, if we can turn back to the transcript at 752, page 10, it said that the claims on ground 1 were that there were no shares, no dividend, no tax, and that submission could not be made, quote, with the same force against EDF.
Sorry, where is that on page 10?
Line 3.
Thank you very much.
However, once again, this explanation doesn't work because Skat had originally sought permission to appeal from Mr. Justice Andrew Baker on ground 1 against EDFM. So the point is that by the time of the Court of Appeal, permission to appeal was not being sought against us, but it had been sought at first instance before Mr. Justice Andrew Baker in respect of the Annex E applications. And you can see that at 775. At paragraph 12, which explained that the reason for doing so, as Skat was pursuing ground 1 on the refund applicants who never owned any shares in a Danish company.
So, I'm so sorry.
Paragraph, page 775, my lord.
Yeah.
And this is a skeleton submission, and I was reading that Skat was pursuing ground 1 only in relation to that part of its case, which concerns WH refunds, which Skat alleges were made by applicants who, in respect of applications, never owned any shares and never received any dividend. And then there's a reference there.
Sorry, forgive me, you're reading from paragraph number
12, my lord.
12, thank you.
Right, but there may have been some people who fell within that paragraph 12, but it was not alleged that the person completing the voucher or the company completing the voucher and submitting it was actually dishonest and knew that that was the situation. Is that the distinction?
No, my lady. I mean, what ground one was being pursued against?
Yes, but I mean, what Mr. Feely's explanation to why some people dropped out, including your client.
Well, we come to that, but at the time of the hearing before the Court of Appeal, Skat knew, at least in relation to EDF Man's Annex E applications, was that there were no shares, no dividend, no tax. And yet when renewing its application for permission to appeal from the Court of Appeal, Skat dropped ground one in relation to the entire claim against EDFM. And we submit that it's difficult to reconcile Mr. Feely's explanation to that now adopted by my learned friend Lord Panic with the fact that Skat knew at the time that there were no shares, at least in relation to the Annex E application. And we heard yesterday from my learned friend that ground one was dropped to avoid making arguments over whether shares made any difference in the analysis. But as you can see from page 11 of the transcript, if we can go back to it, Mr. Feely avoided confirming that that was why the ground was dropped. When twice pressed by, it's at page 752.
And page 10 of the internal numbering.
Yeah, correct. And that's page 11. And then internal line, it then gives a further partial reason, this is internal page 12, line 2, that it was only a very small proportion of Skat's claims at approximately 5%, an explanation that was said yesterday, but rather ironic, as one of the reasons why Skat relies on special circumstances is the large size of the claim. So where we're left with is that the explanation for not pursuing ground one in full, we submit, is inconsistencies and constantly shifting. My learned friend's explanation simply adopts what has come before. It offers no solution to the puzzle. There's no evidence as to why...
I'm so sorry to interrupt, but at the top of page 11, continuing from the very bottom of internal page 10, there's... Mr. Feely says that there was no sufficient basis for advancing a positive case that there were no shares, and that was an important difference so far as your clients were concerned.
Yeah, if you can go...
Are you saying that's wrong?
Yes, and if we can turn to page 19. Just read page 19.
Sorry, internal numbering 19.
Yeah, internal numbering at page 753.
Nice.
So line 17, there were no shares in the sense they were buying from a naked short seller who was not able and did not settle by means of delivery of shares. So my lord, ladies, when we come to the special circumstances, whether it's permission to appeal or whether there are in special circumstances, we submit that there's no explanation that can be given that would explain why the decision was taken not to appeal the decision. Therefore, this is not a case like Arnold, where it was not possible to appeal the decision that's being complained of, and therefore to raise special circumstances at this late stage, where the matter was not investigated, it is simply too late. But even if the decision was taken that there was some explanation that the court could see in this rather confusing account, the question is why is it just that they're not held to the binding decision? A party can make forensic decisions about the best way to progress its case, which point to take. I mean, litigation is full of such decisions, but parties take those decisions knowing full well that while they stand to reap the benefits of those decisions, they must equally bear their consequences. So in my respectful submission, it is unjust to say that there are special circumstances where there is no coherent explanation.
But why wouldn't that point have covered the abuse claim as well? I mean, if people make forensic choices, I would have thought usually it would be an abuse to then pop up later on and say, well, I want to argue this point that I deliberately chose not to argue before.
The abuse point is different. The abuse point is whether or not they should have pleaded a fraud case earlier.
Right.
And that's the Henderson and Henderson. And the court's made findings about the timing of that. That's the abuse case. This is a plea of fraud that should have been made earlier. That's got nothing to do with respect to the question about whether or not they should have appealed, as against my clients, the decision of Andrew Baker on whether the revenue rule applied. They're dealing with different matters. Abuse is about the fraud case being brought when we submit it should have been brought earlier and brought in the first set of proceedings. We failed on that. The court said there was no abuse. The issue that we're looking at now is why there was no appeal. And in my respectful submission, when it comes to special circumstances, the inability to appeal is a highly relevant consideration. That doesn't exist in this case. At best, we've got a tactical decision that they didn't want to appeal as against my client. That decision we submit is incoherent, doesn't make any sense. But we don't know what the reason is because we haven't got the explanation and the special circumstances were not investigated. It's coming out for the first time before this court. And in my respectful submission, looking at the record and the reason as to why it was not raised, why the decision was not challenged, in my respectful submission, it's as Lord Justice Nucci said, at best, obscure. And that remains the case. Now, there is an issue about the same issue between this case and the 2022 claim, but I'll probably leave that until a little bit until later. But what I think I will now do, because of timing, is to look at some of the cases that we've looked at before.
So are you still on special circumstances,
No,
or are you back to issue estoppel?
Back to issue estoppel. Thank you for drawing my attention. Yes, we're back. We say that on Skat's logic, if they are right, it is virtually impossible for issue estoppel to arise on a successful defence, as a party could simply plead an indistinguishably different claim to get around it. And yet English law is clear that defences can give rise to issue estoppels even though the pleaded claims are different. And if I can just illustrate that principle by one authority, and that's the Senna. My learned friend took the court to the House of Lords, but if we could look briefly at the Court of Appeal, and you will find that in the supplemental bundle at page 192. And if I can give the court an oral head note in terms of what the case was about. 192 of supplemental This is the Court of Appeal decision of Lord Justice Cumming Bruce, Carr and Sir Dennis Buckley. And what had happened is that the claimant alleged fraud and negligence against shippers of goods and arrested a ship in England. So that was the English side of it. The same claimant had previously attempted to arrest a ship in Rotterdam, and the Dutch courts ruled that the claim was properly characterised as a claim in contract, and that the contract claim was barred by an exclusive jurisdiction in favour of the Sudanese courts. And if we could turn to page 200 of the authorities bundle, at page 150, in the left column, third line, you will see that counsel...
I'm so sorry, I missed the reference. If you could give it to me again.
Centre number 2?
Yeah, yes, it's just the page reference.
It starts at page 192.
Yes, and you were taking us to a passage.
And I was taking it at the passage at page 200.
Thank you.
Which is in the second column?
First column.
First column.
Left-hand column, yeah, first column, third line. You'll see that counsel for the claimant advanced an argument which resembles Skat's argument in the appeal, that all that the Dutch courts have decided is that the Dutch courts have no jurisdiction in respect of GFG's claim. In other words, the argument went the Dutch court had not decided whether the English courts could decide the claim, and to use Skat's language, the later English courts proceedings were not before the Dutch courts, and so the Dutch courts could not have decided any issue in relation to the English proceedings. And Lord Justice Carr rejected that argument. First, he noted that the Dutch court did have jurisdiction. About halfway down the page, he commented, the argument on behalf of GFG confuses the existence of jurisdiction or competence of the Dutch courts with the question whether or not jurisdiction falls to be exercised. In short, the Dutch court had jurisdiction but refused to hear the claim. And then towards the bottom of the page, Lord Justice Carr rejected the argument for the second reason, that GFG's contention would altogether remove the possibility of any issue estoppel arising from any decision by any court that the jurisdiction clause falls to be applied to GFG's claim. It would allow a litigant to keep running the same arguments in different jurisdictions for no reason other than that the proceedings were different. And then, if we then turn to the House of Lords, which is in authorities bundle 2598. And the head notes at 2598. Just to remind the court what the Dutch court held at the very bottom at H. The district court held that GFG was not entitled to found their claim in damages in tort, but could only found it in the contract contained in the bill of lading, and that by virtue of the exclusive jurisdiction clause in the bill of lading, a Dutch court would be bound to decline jurisdiction in respect of GFG's claim and dismiss the action. And there's three propositions that we say come out of this decision. First of all, it explains what a decision on the merits means for issue estoppel. A decision on the merits is one that necessarily determines an issue by identifying the relevant facts, stating the governing legal principle, and reaching a concluded view as to its legal effect.
I'm so sorry, you're reading from where now?
494
A to B, Lord Diplock.
Sorry, 49 what?
It's 2602, and at page 494 of the weekly's report. So it's
Could you say that again?
2602 to the top there.
02. Lord Diplock at letter A.
Yes, A to B.
Thank you.
And a similar passage appears from the speech of Lord Brandon at 499.
Can you give us the electronic numbering? Sorry.
Yeah, sorry, I should do
it's
that.
my
I
fault.
apologise. It's 2607.
Oh, thank you.
That's a decision on the merits, and Skat takes this point against us, but it's in respect it's difficult to understand Skat's argument, because it's clear that Mr. Justice Andrew Baker did in fact apply the revenue rule to disclose the claim on the merits. The second point that comes out of this is that the case draws a clear distinction between cause of action estoppel and issue estoppel. The question is not whether the same cause of action is pursued, but whether the same issue has been necessarily and finally decided. Once that issue is decided, it cannot be reopened by reformulation. And you can see that from 2607 at page 499H, where counsel for the claimant is recorded as arguing that the issue was different effectively because the claim that was barred from the Dutch courts was framed in contract, whereas the claim before the English court was framed in tort. This alleged difference between the issues was rejected by Lord Brandon in his speech of being of no substance, and you can see that at page 2608, internal numbering, page 500A to B. And critically, the third point is that fraud makes no difference. In the Senate, the English proceedings were framed in fraud, deceit and negligence, and the House of Lords held that that did not avoid issue estoppel. The doctrine attaches to the issue decided, not to the juridical label applied. There is no fraud exception to finality, and you can get that from the head note, which is made, which deals with the point that it was concerned in fraud at 2598, and the references to deceit appear from the speech of Lord Brandon at 495, internal numbering 2603, where you see the reference to fraud, and at 2606 at 298F. So the underlying theme, we say, that this case illustrates is the substance over form. A party cannot escape the binding effect of a prior decision, foreign or domestic, by changing forum, repleading the claim, or elevating allegations to fraud. And therefore that case we submit as a good example of how a characterisation by one court, the Dutch court, which was exclusively in terms of contract and giving rise to an issue of estoppel, could not be avoided by bringing proceedings in England alleging fraud, because there was an issue of estoppel.
Created by the exclusive jurisdiction clause in that case.
The estoppel wasn't created by the jurisdiction clause. The estoppel was created by the decision of the Dutch court to say that the claim was caught by the exclusive jurisdiction clause in contract, and that issue that was as being the forum for this dispute.
I'm being a little bit slow. What was the issue estoppel that was binding in that case?
They had to go to Sudan.
Right, the exclusive jurisdiction clause
Right.
bit and court the claim.
Yes.
Okay.
So now the next thing is the.
So you say that is on all fours in a way with this case, because the claim was in contract in the Netherlands. They construed the whatever the underlying dispute was, the Dutch court said that dispute is covered by the exclusive jurisdiction clause and must go to Sudan. Then the claimants come here. They say, now we're claiming for the same loss, but in tort, and we're alleging fraud. And you say there was held to be an issue estoppel because of the breadth of the instruction that was given to the exclusive jurisdiction clause by the Dutch court that said it covered, in effect, putting it in sort of words that we're familiar with from these proceedings, any private law claims to compensation for this loss are covered by the exclusive jurisdiction clause. And you can't just say, well, they were only talking about the contract claim, now we're talking about a tort claim, so we get to relitigate.
That's my submission.
Yeah.
Now, I want to make the good a point that has come up this morning, which is my submission that issue estoppels are not limited to pleaded claims and facts of the earlier case, but to apply to common issues beyond that. And just for the court's note, we make that submission in our written case at paragraphs 102.
I'm so sorry, Mr. Mallet, can I just check?
Of course.
Was there a trial in the Dutch case, or was it a preliminary issue decided on the pleading?
It was decided as a preliminary matter.
It was decided
Yes.
as a preliminary.
Yeah, I mean, Mr. Temple helps me by referring to the Court of Appeal at page 201 in the Supplemental Authority, the head note. In fact, from the judgment, where there is quite a long discussion as to how an issue of estoppel arises on a decision of a preliminary matter.
201.
Yes. And at 202.
Oh, yes, I see.
Thank you. Now, just to come back to the cross-reference on this question about issues of estoppel are not limited to pleaded claims and the facts of the earlier case. And just for your note, it's 102 to 116. And we say that Skat's position cannot sit alongside cases like Hoisted, Blair and Curran, Arnold, and Watt and Arson. That's obviously not enough time to go through all of those cases, but if I can take Watt and Arson as an example, you'll find that in the authority 2693.
So the authorities were Blair, Hoisted, Watt, and there's a fourth one you mentioned.
Arnold.
Thank you.
My learned friend very helpfully took the court to this decision yesterday. You'll remember that Mr. Arson made a complaint against the Labour Party, alleging discrimination. There was a trial of a preliminary issue, and it was held that the Labour Party was a qualifying body. There was no appeal, and that ruling meant that the employment tribunal had jurisdiction to hear Mr. Arson's complaint. Then Mr. Arson brought 2 further complaints in respect of different conduct against the Labour Party in the employment tribunal. And as you know, after his complaints had been heard, but before judgment handed down, the Court of Appeal in another case concluded that the Labour Party was not a qualifying body. And in reliance on this unrelated authority, the Labour Party argued that the 2nd and 3rd complaints should be dismissed for lack of jurisdiction. The House of Lords agreed that the Labour Party was not a qualifying body, but held that that was irrelevant to Mr. Arson. He had the benefit of an issue estoppel. And Lord Hoffman gave the only substantive speech, and we've seen at paragraph 31, he indicated that issue estoppels can arise from some question of fact of law, and he also specifically referred to such points arising from preliminary issues. So that's obviously relevant in terms of the types of case. And then at 2705 at paragraph 33, His Lordship concluded that the decision that the Labour Party was a qualifying body was made by a competent court and was binding. And in the final paragraph of paragraph 33, he makes the point that the whole point of an issue estoppel on a question of law is that the parties remain bound by an erroneous decision. And we submit that the importance of this case lies in the result of the facts. The case stands, we submit, for 3 propositions. First of all, the determination that the Labour Party was a qualifying body applied between different complaints. That determination was made in relation to Mr. Arson's first complaint. Crucially, his 2nd and 3rd complaints were not before the Employment Appeal Tribunal. The tribunal did not determine anything other about other complaints, and yet an issue estoppel arose in the 2nd and 3rd complaints. Second, the determination that the Labour Party was a qualifying body was a determination that extended to different facts over time. Crucially, the Employment Appeal Tribunal in the first complaint could only determine the quality of the Labour Party at the relevant time of the first complaint, and that's because the Labour Party is not a fact, but a collection of facts that change over time, which could well affect its legal quality. And yet, even though the facts must have been different at the time of each complaint, the issue estoppel applied. The third point is that the reason issue estoppel applied across those different facts is because it was not suggested that the change in facts made any difference to whether the Labour Party was a qualifying body. It is not any factual difference that avoids an issue estoppel, only relevant ones. Now, the fact that Skat accepts that Watt and Arson is correct is important. My learned friend was forced to concede as such when pressed during his oral submission yesterday. He said in answer to a question from Lady Rose about whether issue estoppel would apply in a different context, and what he said, that may depend, in my submission, the facts and circumstances that are presented to the second court. But if the basis of Mr. Arson's argument 2 years later is the same, so it probably would have to be so, because the case doesn't depend upon the characteristics of Mr. Arson, it depends on the characteristics of the Labour Party, then in my submission estoppel would apply. So that one can envisage, however, that there may be a change in the nature of how the Labour Party selects its candidates that may, I stress emphasis, may be relevant to the application of Section 6. And this is precisely our analysis. First of all, my learned friend accepts that an issue estoppel arising in an earlier complaint could extend to a different later complaint. He must accept, therefore, because that's precisely what happened in Watt and Arson. So the fact that the claims before the court are different is neither here nor there. He accepts that the Labour Party is not a singular fact, but a collection of facts, a change in which over time may well affect its legal quality. Third, he has to accept that there is not any change in the facts that avoids an issue of estoppel. Rather, it is a change in facts that are relevant to the issue being determined. Where it is not relevant, an issue estoppel will arise. And we say that analysis applies in the present case. While there are factual differences between Skat's claims which we accept, none is relevant to the question of characterization that arises under the judgment of Lord Justice Andrew Baker in connection with the revenue rule. The key point, and the point I'm trying to get across to the court, is that there's no new relevant facts that are there that could possibly lead to a conclusion that the cases are different. The same characterization question arises. The characterization claim is not at the level of causes of action. It's about the characterization of the Danish state and what it's seeking to achieve, and how that is caught by Rule 3. The claim has got nothing to do with the causes of action in negligence and fraud. So to say, well, it's changed because we weren't alleging fraud, we were only alleging negligence. That was the only claim that was before the court, negligence, not fraud. That, with the greatest respect, misunderstands the nature of issue estoppel. Issue estoppel is about different causes of action, otherwise it wouldn't be there. So there are differences in the cause of action. They are different causes of action, but that does not affect the characterization issue. So in exactly the same way as a case like in Watt, where you've got different complaints, different times, where the facts are different, the issue estoppel applies. It applies from the first complaint and goes through to the second and third complaints. The facts may be different, but the estoppel binds. And that, in my submission, is the significance of Watt of the Watt case. The second point I want to do is to deal with Oisted. Yes, I mean, the point is that there are two separate questions when where it's important not to conflate the concept of necessary and same issue. There are two separate questions which are being, we respectfully say, conflated. The first is whether the issue was necessary to decide the earlier case, and whether the same issue arose in the later case. The first question is whether the point of law was necessary to decide the earlier case. At this stage, of course, it's necessary that the law is applied to the facts. However, once the law is applied to the facts, it is inherent in the issue of estoppel that that issue can then be lifted out of those facts and applied to a different case with different facts between the same parties. The second question at this stage is whether the same issue arises. At that second stage, it is inherent that the issue is capable of general application. That is the only way it can extend to a different claim on different facts. The test at this stage is relevance. That is why we identify if the same issue arises. And we see that in the leading estoppel cases. We've seen it in Senna, which we just looked at. We see it in Arnold, where the decision on one rent review period applied to the facts lifted out and applied to the subsequent rent review periods. We saw it in Blair, where there was a decision on one disposition. It applied to the facts at one point of time, and then it was lifted out and applied to another disposition 20 years later. What is another case? It was a decision on one claim based on the Labour Party at one point of time. It was applied to facts of the first complaint and then lifted out and applied to the subsequent two complaints. In all these cases, the reason the issue could apply to the later case is because the factual differences were irrelevant. But that is a question of necessity to the earlier case, but whether whether the same issue, but that is the question not of necessity of the earlier case, but whether the same issue arises. And just picking up a point made by my lady Simla on the question of appealability. In every case of issue estoppel, it is the failure. It's a failure to appeal the earlier decision, which gives rise to the issue estoppel in the later case. In all these cases, the party couldn't appeal the later case because that was not decided yet. But it's inherent in issue estoppel the decision not to appeal the earlier decision binds the parties in the later case. This, of course, gives rise to the risk of injustice, but that is precisely why the reason that there is an Arnold exception, because the inability to appeal the earlier decision would otherwise have bound the parties into the future. Now, the hoisted case, I need to deal with because it was part of my learned friend's suggestion that the hoisted case, a case that we rely upon as setting out orthodox principles of issue estoppel, is of a dubious authority. We say that that is incorrect with the greatest respect to him. Lord Panic, my learned friend, raised a couple of cases which he said had doubted Hoisted. He referred to the New Brunswick case, and with the court's permission, Mr. Temple is going to deal with New Brunswick. But the short point is that their lordships were dealing with default judgments. Most of them, at least, did not suggest that Hoisted was wrong. The second point is that Lord Panic said it was doubted in the case of Carrefour. Now, just for the court's note, it's at 1143. In short, it was a tax case relating to assessment in Malaysia. The facts don't matter for present cases, but of relevance is the advice of Lord Radcliffe, and again, just giving the reference at 1158. There's a distinction that tax assessments effectively have a separate treatment in the law of res judicata, and there is a reference to Hoisted being inconsistent with that line of authority. But Hoisted is not, in that field, Hoisted was overruled, but that does not mean that Lord Shaw's description in Hoisted about the right test that we looked at earlier is incorrect outside the tax law context. And, my lord, the point, my ladies, the point there is that Hoisted has been constantly referred to in the cases afterwards. I mean, one can start off with the case of Blair and Curran, which predated Carrefour. But if one can turn to the decision at 2710, we can see my learned friend took you to 2778.
Do you want us to go back there?
Well, just briefly, my lord, that would assist.
Sorry, which page?
2778, my lady.
2778.
And if you look at the bottom of the page, we see that Lord Shaw was cited there and Hoisted in the passage that we are relying upon, including the reference to the ratio, provided that part of the underlying Mr. Justice Dixon's approach to the case in front of him. And the analysis of Lord Shaw in Hoisted in Blair and Curran does, we submit, remain part of English law. In fact, if one then turns to the next case on this line, Mills and Cooper, which is in the bundle at 1793, your lordship can see from the judgment of Lord Diplock at 2802 Sorry, 1802. Sorry, 1802.
Where on that page do you want us?
Yeah. The court can see Lord Justice Diplock's judgment, as he then was, at lines E to F. He says the doctrine in civil proceedings is fairly recent. Although hoisted and taxation did not purport to break ground, it can be regarded as the starting point of the modern common law doctrine. Again, showing its significance. And then at 3290, there's a reference to Spencer Bauer.
Sorry, page?
3290.
This is the current edition of Spencer Bauer, is it?
Yes.
Yes.
3290 is an extract, as I say, and we can see 7 down line. He says the term was in fact coined in hoisted case, but in a dissenting judgment. And in fact, it's clear that the first use of the word in England of the term by Lord Justice Diplock was in Thorday. At least that's what was said in Virgin Atlantic. And again, the reference to the importance of hoisted, you can see from Blair and Curran, which is at 3294. But 5 times up from the bottom, where it said that where the decision necessarily involves a judicial determination of some law of fact because it could not have been legitimately or rationally pronounced without determining or assuming a particular answer, that determination, though not expressed, is an integral part of the decision. And if you see at footnote 12, there's a reference to hoisted and the suggestion that, although no longer authoritative in annual tax cases, since Kafur, it remains a valuable exposition of the general principles. That we say is correct. Then at 3296, at paragraph 811, hoisted is relied upon with a long quotation, which includes the passage I've referred the court to. And then at 3302, paragraph 8.23, at the bottom of the page, this sets out the test of determination needing to be fundamental, not collateral. And at the very bottom of the page, we have a reference.
Sorry, I've lost you.
3302?
3302.
Either line on the page. And again, I don't think I need to take you to it. Hoisted was referred to in Arnold. And in fact, if you did a Westlaw search, you'll find that the case is repeatedly referred to. And although my learned friend said the Duchess of Kingston's case is the fons and origo of the jurisdiction, we respectfully say that, consistent with what Lord Justice Diplock said in Mills and Cooper, we say that hoisted is the case that should claim that title. Now, the next point I want to deal with is this related to this about the...
Were you going to take us to hoisted
Yes,
to show us the bit you want to rely on?
The bits that we referred to earlier from the speech of Lord Justice Newey.
Right. I mean, speaking for myself, I would be assisted by looking at hoisted because you put so much weight on it.
Well, yes, we will do that.
All right.
Can I just deal with this question about the reasoning and ratio decidendi, which I touched upon earlier today? And the argument that was being made by my learned friend is that it's wrong to look beyond the ultimate decision at the reasoning of the earlier judge. So that's the suggestion, that it's wrong to look beyond the ultimate decision at the reasoning of the earlier judge. I mean, the starting point is that Skat's own case, the issues which are necessary and fundamental to an early decision can give rise to issue estoppel. And you'll see that at paragraph 86 of its written case for your note. Thus, this simply cannot be limited to the ultimate decision reflected by on the face of the order, which the court rightly pressed my learned friend on yesterday. We say that determining what is necessary and fundamental to a decision involves the same interpretive exercise as identifying the ratio of a decision. Now, as I said earlier today, we don't say that res judicata and judicial precedent are the same doctrine. They're not. They have different doctrines with different functions, different rules. But there is a commonality in that they both depend for their operation on identifying what is necessary and fundamental to a decision. My learned friend took you to Lord Justice Leggett as he was then judgment in the Youngson case. If we can just go back to that. It's in the bundle at 2069.
Yes.
And if we could turn 2069, we'll note at the end of paragraph 48, the judge is quoting from Cross and Harris, which says that the ratio of a case is a necessary step in reaching a conclusion. But
I think he's there talking about ratio in the sense of precedent, isn't he?
Yes.
Right.
Which was obviously with the issue that was before.
Because I thought we'd established that ratio, as used in the sense of issue estoppel, has a slightly different.
Yes, and then we saw that Lord Justice Leggett, as he then was, quote, cited Cross and Harris. And if we can just look at that briefly at 3143.
So, this again is talking about ratio decidendi in the context of a precedent, isn't it?
Yes, but if one turns to 3142, where, and this I think where it said that the fundamental differences concern. So it's 314. So page 3143
Yes.
we can see the fundamental differences concern judicial hierarchy and the range of those affected. Only ratios descendere of superior courts create binding precedents. A cause of action, estoppel, and an issue estoppel may be pleaded by parties affected by the earlier litigation. And that corresponds to the point that the Deputy President made yesterday. Precedent and issue estoppel are different doctrines. They bind different parties in different ways. However, we say that the interpretive process of identifying the necessary reasoning is the same. And if we turn back a page to a section I don't think we looked at, which is 8 lines up from the bottom, what is said there is that there are some resemblances between res judicata and binding precedents.
I'm so sorry. The page reference again?
The page reference is 3142.
Yes.
The last paragraph there.
Thank you.
There are some resemblances between res judicata and binding precedent in the first place. In the first place, if a ruling is giving rise to an issue estoppel, it must, like a ratio descendi, have been necessary to the decision in the earlier case. And that's the point that...
I'm awfully sorry, you're reading from the bottom of 3142?
3142, the last complete paragraph.
Yes, thank you.
There are some resemblances between res judicata and binding estoppel. In the first place, if a ruling is to give rise to an issue estoppel, it must, like ratio disadendi, have been necessary to the decision in the earlier case. That's where the similarity is. And the passage goes on to discuss Restate of Norway's application, and the Court of Appeal in that case rejected an issue for the same reason as it rejected the suggestion that it was part of the ratio decidendi. And if we can then turn to Blair and Curran, which we've looked at already, which applied Housestead, we can see that at 2779. And here, about halfway down the page, we see that the relevant part of the order of Mr. Justice Street, which Justice Dixon was considering, and the order declared that on the death of the widow of the share in which she took a life interest passes under a gift in the said will of the residue of the testator's Tasmanian property. So the order dealt with a specific bequest. And in the case before him, Mr. Justice Dixon had to decide how that impacted on a second failed bequest that he was considering. But halfway down, he referred to 2 questions that must be asked and answered in deciding whether an issue estoppel arose from this determination. In the passage which begins about halfway down, he said that the 2 questions were, the first is whether the declaration quoted necessarily involves the proposition that an interest in the business of conducting a sweepstake, if not otherwise validly disposed of, falls under the clause of a residuary gift of Tasmanian property. The second is whether this proposition is the immediate foundation of the declaration, as opposed to a proposition collateral or subsidiary only, that is no more than part of the reasoning for the reasoning supporting the conclusion. And on that second question, I stress that the reference to a collateral proposition being no more than part of the reasoning, this is not a rejection of estoppel attaching to reasoning at all. It's a rejection of estoppel attaching to subsidiary arguments, that is, considerations which tend to support a legal conclusion but not themselves determinate of the outcome. What matters is whether the judgment could stand without it. And then Mr. Justice Dixon said that both questions should receive an affirmative answer. As to the first, the declaration on its face describes the clause as a residuary gift of the Tasmanian property, and there is no legal hypothesis which could account for the widow's life interest passing under it consistent with a narrow interpretation or effect being given to the clause than that stated. So we have here Mr. Justice Dixon looking for finding the ratio of the previous decision that all failed bequests relating to the Tasmanian property should be dealt with in a particular way. But importantly, Mr. Justice Dixon was dealing with a different claim from that which Mr. Justice Street had and the issue estoppel applied. Now, Skat's argument is that issue estoppels can only attach to the same claim or preliminary issue in the earlier claim, but applying this reasoning to Blair and Curran, and it can be seen that that just doesn't work. Mr. Justice Street determined one question, the widow's interest, but the issue estoppel wasn't limited to that precise question. It extended to the ratio that underpinned that answer. So that sort of sets the scene. I've now then got to deal with...
It was seen to be the immediate foundation of the declaration.
Correct. Yes.
You say that applies here?
Yes. It applies here because your Lordship has my submission, which is that the characterisation issue that was decided by Mr. Justice Andrew Baker was the applicability of the revenue rule in the context of private claims in relation to misinformation and a claim to recoup the fund. And in our submission, that is the reasoning that applies across to this one, and that references to different causes of action. And that's why Mr. Justice Dixon framed the inquiry in terms of whether the determination in question formed the immediate foundation of the decision. The determination is immediate in this sense if it is necessary to justify the result. So we say that properly understood necessary and immediate foundation are not separate hurdles. To say that a determination was necessary to the decision is simply a different way of saying that it formed part of the essential groundwork without which the decision could not rationally stand. And the reasoning and result of Blair and Curran itself, we submit, illustrates that point.
Yes. Mr. Ballard, is that a convenient?
It is, Michael. Thank you.
Thank you. Very well. We'll rise now. Resume at 2.